Hey guys, my apologies, man. I'm been having problems ever since I went live earlier on my phone. I've been having like security issues with my phone, and I'm not even able to get on live from my phone. It's crazy. I don't know. It's still telling me log in and ah, woosah. No, still giving me issues. I don't know what that's all about. See, look, it's giving me like this thing here, and it's not letting me log in. Every time I try to log in, it's crazy. It tells me to try again. This is what I've been doing all this time. It's frustrating. You see, look, it says too many time attempted. Look, you see, can't get into my account. Ah, these people, man, they locked me out of my own account. It's crazy. No, that's my regular phone. It's not even my iPhone. This is my Android. The iPhone is fine. I can get into the iPhone one. It's my Android. It's my Android. Yep, it's my Android. I'm sorry, y'all. I'm a little irritated with this whole phone thing. Give me a second. I need to get me some water. Just 1 second. I'll put some music on. Give me a minute. Let me just put some music on. I don't know. I can't even get into my phone. Don't know. I do have the interview from today. I have the interview. Just hold on a second. Let me put some music on. I'll be right back. I gotta go get me some water. I apologize. I just get a little discombobulated right now. Hold on a second. All right, guys, I apologize. I'm sorry. Stephanie, you keep caught up. I'm slipping. I missed the notification. Okay, y'all. You guys are ready? My apologies. I apologize. I just got discombobulated because I was not able to get into my phone. I don't know. I don't know. I don't know. When I was on the live earlier, it said something about a small malware or some crap like that. I don't know. But anyway, let me just get myself together here and start with my commentary. Okay. Good afternoon. Had to get my water in. Let me. He said check my email. Check my email. He said check my. Okay. Why do y'all gotta have me to check emails now? I know I'm already late and discombobulated. So hold on. Now I gotta try to. I can't even get in my other emails. Okay, well, what are you doing? Okay, I don't have anything from you for email. I have anything. So check my email. I don't have anything. My email. Nothing. Okay. Nothing's in my email. Okay, y'all. Let's go ahead on and get started. All right, let me go ahead and hold on a second. I left the All right, I'm gonna go ahead and play this morning's video, and then I have the interview with attorney Eric Johnson. Attorney Eric Johnson, regarding what happened to him today, and all right, let's go. Let me pull up this. All right, today, they had a special hearing in regarding to temporary restraining order on Mr. Eric Johnson's computer, and the DA office out of Gwinnett decided to put in a new search warrant for the computer, and they put additional charges and information on the warrant. I'm going to read to you guys what the warrant says, as well as why there was probable cause. And in that warrant, they named Mr. Eric Johnson as a co-conspirator because he allowed the Mr. Eppinger to use his computer, which was allowed, but Mr. Eppinger was not allowed to go into like social media, using his page for IG to contact the deputy. You know, the deputy was arrested, and some sort of relationship that the deputy and Mr. Eppinger had. So it's a lot of stuff. There's some things that are alleged that I'm going to share with you guys, and there's some things that are actual factual. One of the factual thing was he was in contact with the deputy, and that was found in the first search of the computer, and that's how they were able to determine that she was the one that he was in contact with, and she was arrested. So therefore, that part is not alleged, but the other things are alleged, like Mr. Johnson being a co-conspirator. That's alleged. Okay. I did manage to get an interview with him in regard to the case. And you guys know that Eppinger's case has been severed. And the reason why it has been severed, because there is like a conflict going on. That conflict is because now Eppinger and Johnson are considered to be co-defendant or co-conspirator, and not defendant because Johnson has not been arrested, but Eppinger, he cannot represent Eppinger in the case right now because of this conflict that's going on, because Eppinger's computer is being seized and he is considered to be a co-conspirator in the case, in the search warrant request. Okay, I'm gonna go and I'm reading some of this stuff with you guys, but prior to that, I need to go pull up. Hold on a second. All right, guys, I cannot. I'm discombobulated right now, so please, guys, curtail some messages right now because I'm trying to get this stuff here fast through instead of me focusing on this computer phone stuff, this issue that I'm having with my phone. So I'm gonna do one thing at a time, because right now it's just so discombobulated. But okay, let me go ahead and pull this up for you guys. Let me get myself over here for a second. Just 1 second, let me pull it up. Okay, I'm gonna pull up. Hold on 1 second. Let me just go ahead on and get this other thing for you. I'm gonna put on the music again. Just 1 second. My apologies. This is a crazy day for me right now. Just 1 second. Let me just put the music on and I'll be right back. Right back. All right, guys, let's go ahead and let me share this with you guys. Okay, the individuals you're seeing right there is that Gwinnett attorney, district attorney, who is representing the state in this case right now.
Are there any affidavits? Okay, did you talk to the student? She, no, she's on part time. Okay, and the child caregiver? Yes. Okay, awesome, thank you. No problem. Oh, yeah, no, I'm here, I'm coming back, but, since I'm here, I'm gonna answer some. Okay, thank you. Here is your coffee.
This is right here. I'll push that as well. I was just serving that came to what she's returning. She goes to
Yeah, do y'all see Thug's pants? Did y'all get a chance to see Thug's pants? Check out his pants, y'all. He got pants like a cowboy with the fridges around it. Did y'all get a chance to see it? Okay, now we talk about his pants by everybody. Now everybody else gonna say something about his pants, right? We saw that at court, so take a look at his pants. He got some white fridges. Where's his pants? Y'all see his pants, y'all? Y'all see Thug's pants? Look his pants. Did you guys see his pants? Who saw his pants? They're asking about me right now. They're asking about me because I was standing outside trying to get in, and they refused me again. The officer went to that's who I talked to. I talked to her, and she talked to see, now he gonna tell me no. This is when they tell me no. See, now she's coming over. You see, she's coming over to me now. I'm in the back. They rejected me again, y'all. They had me and this other young lady in the back this time. They claim it's for security reason for us not to be in there. I'm not gonna fight it anymore. I'm gonna leave it alone.
Restoring. Not to know if I get it.
Hi, good morning, council's interested parties. We're back on the record in the matter of the state of Georgia versus Khalif Adams et al. In 22 SC 183572. We'll go ahead and take roll at this point in time this morning. Mr. Beebe, Mr. Partridge. All right, good morning. Mr. Stillwell and Mr. Box and Mr. Sharp, good morning. Mr. Williams and Mr. Steele, good morning. Good morning, Your Honor. Mr. Kendrick, and let's see, is it Ms. Hingerty? Good morning. Mr. Ewing, Mr. Matthews, Junior and Senior, good morning, gentlemen. Mr. Nichols and, oh, I need to buy a lottery ticket today, Mr. Harvey. Okay, all right, good morning. Mr. Dorsey and Mr. Jimenez. Good morning. Good morning. Mr. Eppinger and Mr. Johnson, good morning, gentlemen. And Mr. Ryan and Ms. D. Williams, good morning. All right, and for the state this morning, for the purposes of the motion for the TRO, I believe we have, is it Mr. Delfont and Ms. Talley from Gwinnett County, is that correct?
Yes, Your Honor.
All right, good morning, welcome.
Good morning.
Okay, I understand you all are here because your district attorney was appointed because our district attorney, Ms. Willis, had to recuse herself on this matter, is that correct?
Yes, Judge, that's correct. We were appointed by the Prosecuting Attorney's Counsel, Ms. Austin Gatson from the Gwinnett Judicial Circuit, and I'm appearing here on her behalf along with Ms. Talley.
Okay, all right, well, welcome. All right, maybe see, so you're good. Let's see, Ms. Frankelson and Mr. Randolph, good morning.
Good morning, Your Honor.
Okay, all right. Do I have anybody from our district attorney's office this morning? Because I'm
present, Your Honor.
Oh, okay, okay, Mr. Smith, and who else is with you? Anybody else with you? Because I'm going to take up this matter first, and then I can go ahead and continue with hardships. All right? Okay. So is Ms. Love going to join us at some point?
She would, Your Honor.
Okay. All right. Just want to make sure. Okay. All right, my first question I'm going to ask to our district attorneys, Mr. Delphine and Ms. Talley. Counsel, have you had the opportunity to take a look at the warrant that was filed in this particular case, as well as did you file any responsive pleadings to it, in response to it?
Judge, the warrant that was filed, the motion that was filed by Mr. Short on behalf of Mr. Johnson.
Yeah, both.
Judge, I've reviewed the warrant that was taken out by the Fulton County Sheriff's Office, Sergeant Davis. I've also reviewed the motion that was filed by Mr. Johnson, and I've reviewed the court's order in response to that motion, and I'm prepared to proceed forward on that this morning, Judge.
Okay. I guess.
Okay, before I continue with this, I'm going to read to you the warrant that he's talking about. I'm going to read what it says by the investigator, the affidavit of the warrant for the search, because that's what they. Oh, well, and let me finish playing this, because at one point I'm going to tell you what happened, why they had to redo another warrant for a search. Okay, 1 second.
Initial question I have for you. Do you believe that the dictates of 17-5-32 C and its following sections were followed?
Judge, I do not. And the state is, this morning, we're appearing, and I will not contest the insufficiency of the warrant that was obtained on May 30th.
Okay, so they're saying the warrant for the search that was done on May 30th, there was it had some insufficient, it had some deficiencies in it. So therefore they had to do another warrant as of today, and they have 10 days to exercise that warrant. So what's going to happen is they're going to have Mr. Eppinger to bring the computer to the judge. The judge has to get the computer, and then they're going to give it to the district attorney, because it will fulfill the warrant for the search. But then they have to give it back, because the judge is giving them 15 days to have a hearing regarding that. And with that hearing, they're going to have a master person to oversee them looking into the computer. Okay, but they have to fulfill the warrant that they're exercising today in order for them to have a corrected search warrant. Okay, because there was a mistake done with the other one. So they have to redo a new search warrant, and they have to fulfill it. They have to do it within 10 days. I'm just explaining to you what happened, but let me play it now.
By the Fulton County Sheriff's Office. A caveat to that. The Fulton County Sheriff's Office investigator McCormick this morning in front of Judge Keaton swore out a different warrant. I provided that to defense counsel, Mr. Johnson, and I have a copy for the court as well, for your consideration as well. That being said, the new warrant lists a lot of additional information that was not contained in the first warrant. I do not believe, and this warrant was not done pursuant to 17-532 either. Despite it being signed by a Superior Court judge, it does not allege to be done pursuant to 17-532. The reasoning behind that, and as you read the warrant itself, Judge, is that the state is alleging in this warrant that Mr. Johnson is a co-conspirator in the offense of providing.
Now you hear this, right? So there is a ruling that Mr. Johnson, not ruling, there was a motion that Mr. Johnson submitted. In that motion, he said that the search warrant was illegal, that it was done by the state of Georgia, by the state. And they said the reason why, not the state, by the deputies, the reason why he said it was illegal is because he was not a suspect of the search. So therefore, his computer is protected by attorney-client privilege. But now with this new search warrant, they put in him as a co-conspirator. So therefore, he is not covered by that particular law or rule that they were originally, when they first took the computer the first time. But now they're saying he's considered to be a co-conspirator, so they don't have to deal with that particular ruling. It's unfair, but they did it that way. You hear what I'm saying? So, okay. But still, he still has to have the hearing because the judge or did a temporary stop on it. So they have to address that. Okay. So they're saying they're trying to bypass it by saying they're putting him as part of he conspired with Mr. Eppinger to be able to get on that computer or some stuff like that. But here's the problem with that. The court gave the defendants approval for them to be on the computer to look at the evidence and things like that, because evidence is included in social media and all this kind of stuff. But see, Eppinger went one step further. He started contacting that woman behind the scene. See, they made a probable cause saying that the reason why they want to search a computer because Eppinger was talking to other YSL, but that was not the fact. They knew that Eppinger and that deputy was in communication with each other, but they needed to get into the computer. So they made up, I'm not going to say they made up, but they came to the conclusion that he was contacting someone from ISL. But here's what really triggered it. I'm going to read to you what triggered the whole thing. Because when Eppinger got into that spat in the jail with that individual, when the individual got stabbed, the same deputy was there and she did nothing. And that what kind of triggered them to look at everything. Okay? Guys, you understand what I'm saying? It's a lot of like weird stuff that's going on, but I'm trying to explain everything to you. I'm getting ready to read this affidavits right after I finish one part of this, okay?
Prohibited items to inmates, because there is probable cause and the Superior Court judge has found probable cause, and Mr. Johnson is also a party to this crime. A magistrate judge or Superior Court judge can sign a search warrant for his property without adhering to the subsection 17.532 subsection C or B for that reason. I have a copy for the court if you'd like these on it.
Yes, and has one been provided to Mr. Johnson?
I have, Judge, previously
Okay.
taken the bench.
All right, okay, if you can approach him, that's me, please.
So do you guys understand what just happened? The original search warrant that they put out, the original search warrant was not legal. So, but they end up finding something in the computer that caused that deputy to get fired, right? To get arrested, not just fired, but arrested because they got it on illegally from the attorney's computer. Now, so they don't have to deal with the ramification of it. They went and did another search warrant, but with this time they put the attorney as a co-conspirator, saying that he's part of the crime. But how is he part of the crime when the court allowed the defendants to use the computers of the attorneys? This is kind of weird. So, but I guess they're saying that he should have been watching him. But it's impossible to be watching him because half of the time if they leave the computer, they tell them to leave the computer there and they go to the bathroom or go to lunch, those defendants are in the room by himself. I can show you videos of the defendants in the room, for waiting for them to go to the back and for lunch and things like that. So it's kind of catch-22 on this. But let me go ahead on and play my exclusive interview with Mr. Eppinger so you guys can hear what he said. This is only from Infamous Sylvia. I might talk in between it because people could try to take my stuff. Hold on. All right, here we go.
Okay, so basically, like, because of the Instagram thing that the search warrant says, what does that have to do with the clerk that they were mentioning in the case, like his conflict with the clerk? You know what I'm saying?
The deputy.
The deputy.
Oh, well, what happened is, throughout the course of the case, the attorneys have we all have been authorized to allow our clients to access the information, the discovery of things of that nature in the court. Some of that information consists of YouTube videos and other things that may need accessing the internet for. However, my client, Mr. Epinger, has been alleged to have been having improper communications with a deputy. One of the deputies of Miss Stanley, who was in the news last week on Instagram. So that is what I'm going to talk about, the conflict between the deputy. He was allegedly having inappropriate conversations with the deputy while using my computer.
Understood. So therefore, that would then make you a co-conspirator.
Allegedly.
Due to the use of your computer. Understood. So where do you go from here now that he is severed from the case?
He'll most likely be tried on his own with some of the other defendants that have been severed from this case already. As you know, this case started out with 28 co-defendants. So there have been people who have been severed for a variety of reasons.
So this is what is happening. Hold on.
For bringing in some personal prescription medication. There were 2 individuals who were severed because their attorneys were pregnant and expected to deliver soon, and then other individuals who were severed for a variety of reasons. So he may be trying with him, or he may be trying by himself, depending on how the state chooses to proceed.
So will you still be representing him when he goes to
I
trial?
was appointed to represent Mr. Epinger, so probably I may still be appointed to represent him when this case comes back up. Sometime down the road, we don't know what happens.
Do you think that the outcome of Mr. Evinger's case specifically will be affected by the fact that he was severed from the case or not?
I think it has the potential to. I think it definitely has the potential to, based on the circumstances he has now. I believe him being tried by himself may make it more difficult for him to obtain a not guilty verdict, which we will be seeking in this particular matter. But that's just my professional opinion. It may or may not transpire.
So as far as the case with the deputy, will you have to show up for that? Because I heard that they're putting you as a suspect, allegedly a suspect.
Well, I most likely won't have to show up for that. I would probably be, if it goes that way and the state makes the determination, that would most likely result in a separate charge against myself. That would be a separate matter that would have to be handled. So hopefully it doesn't come to that, because I do not believe that the facts and circumstances would merit that. But if it does come to that, then my situation would probably be handled separate from others.
So that means that you were given permission for them to review the case and information on your laptop, right? But so were you supposed to be monitoring him and the usage, or?
Apparently, based on what the state is alleging, that was saying the case, is that we were supposed to be 100% vigilant over everything that they did on the computers every single moment of the day, which is somewhat impossible by us attending to other matters during the court. So, but their allegations would seem that is what they're expecting by trying to say that I'm allegedly some type of co-conspirator, because there's no information, and there will be no information that I provided an Instagram account for him to use, that I participated in any Instagram communications. It'd be more so me not monitoring his use of the computer to the degree that the state felt I should have at this particular point.
Well, I thank you for your time.
Thank you so much for speaking with us.
So thank you.
We appreciate it.
Thank you.
Okay, that was me and the young lady. The 2 people that they have in the back, her and I, we decided to run up and ask him questions, and we were able to get the information from him regarding on how everything, what he was feeling and how things were going. So I will be having a face-to-face interview with him later on, but I just wanted to catch him and see how he felt and what some of the things that was going on. But now I'm going to go ahead and read the actual search warrant for you guys. I was able to obtain that as well. So let me go ahead and finish playing this, and then I'll read the search warrant. and the change. I'm gonna read the original search warrant because I have that, and then I'm gonna read the new search warrant and what it says. It basically says the same thing. It reiterates the probable cause because they have all these other things listed that happened during the trial. So this gave them more like ammunition of being able to, fortify the reason why they requested the search warrant. Okay.
Who's ever got that on, could you please turn it off?
It was talking about people born between 1968 and after, so it clearly doesn't apply to me. But I'll have to do it.
And they're going to have a conference between the judge in the judge's chamber, which will not include the state, because there's some things that they are very concerned about. This is very much of a sloppy case to me. This is Sylvia's opinion on this. This is very, very sloppy. This is very, very, very sloppy.
Mr. Johnson, where are you? Good morning, sir. Sir, if you had the opportunity to digest the warrant at this point in time,
Not fully, Your Honor.
all right, do you wish some time to do that?
Yes, sir, Your Honor.
All right.
Yes, Your Honor, based on the statements of the state at a particular time and the allegation of my involvement in this matter, I think I'm going to apply to request counsel at a particular time. So I request that continues to obtain counsel for this particular matter and to review the warrant and affidavits.
I didn't think that would be more than appropriate. How long do you need, sir? 10 days sufficient or thereabouts?
15, Your Honor.
Let me see what I have available because, and let me take a look at my calendar.
Excuse me, Judge.
Could you give me a second, please?
Sure.
Mr. Harvey, thank you. Wes.
Okay, what I'm gonna do, I'm gonna go ahead and read the warrant, the search warrant for you guys. I'm gonna read it, and this is the affidavit for the search warrant. Okay, personally appeared before me, Investigator McCormick, an officer of Fulton County Sheriff Department, charged with the duty of enforcing criminal law, who in his official capacity and after being duly sworn, deposes and on oath says that he has probable cause to believe that the evidence which is subject to search and seizure as tangible evidence of the crimes of the prohibited items to an inmate within the custody and control of the custodian of Mr. Eric Johnson, custodian of Mr. Eric Johnson, located at 185 Central Avenue, Atlanta, Georgia, 30303. There is now concealed concern evidence to wit the internet browsing data, cookie, and social media accounts, platforms that are located within the internet browser history, which have instant messaging, text messaging, and video messaging capacity, and a search of the system setting for the purpose of locating the product ID and other unique identifying characteristic located on an HP Windows style laptop with a black keyboard. I am requesting a search warrant for the above laptop, and they give the laptop number and all that, right? Which belongs to Eric Johnson. Mr. Johnson is the attorney for Christian Eppinger, who is one of the defendants in the YSL RICO trial. I am Investigator A. McCormick, who is a member of the Fugitive Apprehension and Support Team, FAST, FAST, with the Fulton County Sheriff Department, FCSO. I have been post-certified in the state of Georgia since June 2019 and previously worked with the Atlanta Police Department. I have hundreds of hours of investigating, which include criminal gang activity, narcotics, and fraud. I have sworn out numerous search and arrest warrant throughout my career. The following is the probable cause for the search and seizure of Mr. Johnson's laptop. Overview of trial proceedings. The YSL trial commenced on January 2023. FAST and other specialized FCSO unit have been assigned as additional court security due to the dangerous nature of the YSL gang and the action of co-defendants. I and FAST as assigned to go to 901 Rice Street every morning that there is court and wake up the inmates and search them for individual transport to Fulton County Courthouse. I'm going to pause right there. They're supposed to search them every day. So how is it in the world that that young man was able to have the underwear with that stuff? I just had to pause right there. All right, let me finish. They are separated due to previous incident, including a few of the YSL co-defendant showing violence against other inmates being transported to the courthouse. We are stationed inside courtroom 1C to assist and maintain order due to how many defendants are on trial. Courtroom security incidents. Because the large nature of the prosecution and the nature of the charges and the defendant's affiliation with criminal street gang, YSL and numerous incidences of violence and possession of contraband in the Fulton County Courthouse courtroom to date, FAST has been on heightened alert and daily monitoring the action of individuals inside the courtrooms. Some of these incidents are detailed below. On January 18, 2023, Khalif Adams was arrested and charged for attempting to conduct a hand-to-hand narcotic transaction in the middle of the Fulton County Courtroom 1C. This incident made national news, and the illegal narcotics were removed when he attempted to conduct a handshake with Jeffrey William YSL member. When further checking court surveillance footage, Mr. Adams obtained illegal contraband from Mr. Christian Eppinger, who was sitting behind him. Did y'all hear that? We didn't get to see that in the video, did we? We didn't see Eppinger having the drug gave it to the guy Adams. We didn't see that. The only thing we saw they allowed us to see was when it was given to, when it was trying to give it to Jeffrey. But they didn't show any footage of the other part. But they put the part with Jeffrey all over the news. That was strange. All right, let's continue to read this. All right. On April 17, 2023, Mr. Tanquarius Mender was charged with crossing guard lines with a large amount of narcotics that he was attempting to bring to court back in Fulton Jail. In total, Mr. Mender was in possession of approximately 23 grams of raw marijuana, 79 grams of MDMA, 12 grams of Percocet, 1.8 gram of morphine pills, one large amount of loose tobacco, and loose cigarette. On April 19, Mr. Rogelus Ryan was charged. Hold on a second, y'all. Hello? Sorry about that. That's Mr. Ronald. Just hold on a second. In a few minutes, I'll be running to get something from him because he doesn't want to come in the house. All right. It says, on April 19, 2023, Mr. Rogelus Ryan was charged with prohibited items when deputy located approximately 6 grams of raw marijuana that was sewn into his underwear. This was noticed by deputies in the Fulton County courtroom when Ryan had a strong odor of raw marijuana emitting from his person. On April 20th, and Ignacio Mantis, the attorney representing defendant Miles Farley, YSL defendant, was arrested for attempting to bring in pills not in the original container into the courtroom. On May 16, 2023, Mr. Christian Eppinger was charged with felony obstruction ×2, one in the morning time by investigator McCormick, Sergeant Davis, and Deputy Peterson and Deputy White were in the elevator when Eppinger and Dorsey, when they refused lawful order to face the wall so the elevator code could not be placed. It is imperative that inmates do not know this code to maintain jail security. On May 16, 2023, Mr. Eppinger was transported to Fulton County Courthouse detention. Mr. Eppinger exited his cell, and detention officer Catter gave him a verbal command to return to his individual cell. Mr. Eppinger began yelling back at D.O. Catter and continued to approach him. D.O. Catter confronted Eppinger, and there was a violent altercation when Eppinger had to be restrained. Other deputies assisted with the detaining, except for Deputy Stanley, who stood by. They saying she stood by when Eppinger was doing what he did, and all the other deputies was trying to, contain him, and she stood there and watched and did nothing. Okay. They say laptop rules in courtroom. Because discovery is voluminous, you know how I say that word, and stored electronically is a large part. Chief Judge Glanville, by oral pronouncement, permitted the defendants to use electronic device for only the purpose of reviewing electronic discovery. The laptops and tablet are to be used exclusively for looking at evidence regarding their case and not for communication by the defendants to other inside or outside courtroom. Mr. Eppinger access to a laptop and utilized that laptop while in court. The laptop that Mr. Eppinger possessed belonged to his attorney, Eric Johnson. Mr. Johnson brings the laptop into the courtroom each morning and provided it to Mr. Eppinger for his use. Illegal laptop use in the courtroom. From the beginning of the trial in January 2023, FAST has repeatedly observed numerous defendants, including Mr. Eppinger, use their laptop as a communication device, which is prohibited. OCGA 42-5-18 describes that it is not permitted to be possessed by an inmate or provided to an inmate. One of those prohibited items is telecommunication device, which OCGA 42-5-18 define as follow. Hold on, y'all. Ronald's calling me back. Hello? Okay. All right, guys, I'm sorry, I'm back. All right, where was I up to? Hey, Gucci. Okay, hold on. I have to breathe hard. What was I up to, y'all? Who remember the word I last read? Okay, I'm gonna just read from illegal laptop use in the courtroom. Okay, from the beginning of the trial, in January 2023, FAST has repeatedly observed numerous defendants, including Mr. Eppinger, use their laptop as a communication device, which is prohibited. OCGA 42-5-18 describe that it is not permitted to be possessed by an inmate or provided to an inmate. One of those prohibitive items is a telecommunication device, which OCGA 42-5-18 defines as the following. Telecommunication device means a device, an apparatus associated with a device, or a component of a device that enables or may be used to enable communication with a person outside of a place of incarceration, including a telephone, telephone, personal digital assistant, transmitting radio or computer connecting, or capable of being connected to a computer network by wireless or other technology, and otherwise capable of communicating with a person or device outside of the place of incarceration. Since January 2023, members of the Fulton County Sheriff's Office have repeatedly warned Mr. Eppinger and his attorney, Mr. Johnson, regarding misuse of the laptop that Eppinger is supposed to be utilizing to review electronic discovery. Approximately in February 2023, FCSO Deputy Rachel Grayson spoke to Mr. Eppinger and his attorney, Mr. Eric Johnson, directly. Deputy Grayson advised them that she saw Mr. Eppinger on Instagram. Mr. Johnson advised Mr. Eppinger to knock it off when the deputy told Deputy Grayson to stand down about her intervening in illegal activity. Huh? Mr. Eppinger. No, okay. I got to go back to it. I thought he was talking to the attorney. Okay. Mr. Johnson advised Mr. Eppinger to knock it off. So the attorney told Eppinger to stop it. Okay. Then told Deputy Grayson to stand down about her intervening with illegal activity. So he told the attorney to stand down too. Okay. On February 2023, FSO Deputy Adrian Talton advised that he walked up behind Mr. Eppinger while he was actively using Instagram and told him to shut it off. Deputy Talton advised Mr. Johnson was sitting directly next to Eppinger. Deputy Talton also gave another warning to Eppinger in April 2023 due to similar activity. In February or March of 2023, FSO Lieutenant Tequila Walker spoke directly with Mr. Eppinger and his attorney, Mr. Johnson, due to her observing Eppinger utilizing Instagram on the laptop. In January 2023 and March 2023, FSO Lieutenant Tamara Lee spoke with Mr. Johnson and Mr. Eppinger in reference to improper food and illegal laptop use in the courtroom. Since January 23 and in the beginning of trial, FSO Deputy Void witnessed Mr. Eppinger on Instagram on 3 to 4 occasions. And Deputy Voigt warned Mr. Eppinger and Mr. Johnson each time to stop accessing Instagram and improperly utilizing the laptop. On May 18, 2023, at 185 Central Avenue, Fulton County Courthouse, in courtroom 1C, FAST members were sitting in the courtroom and began to notice that one of the defendants, Christian Eppinger, seemed to have a second window open on the laptop. This secondary window was cropped to a small and only take up a bottom of 1/4 of the physical laptop screen. This is strange since the laptop screen seems to be at least 13 inches inside. Mr. Eppinger was obviously typing something that was on the bottom quarter of the screen. Investigator began to notice that he couldn't see exactly what he was doing, as it appeared that he was attempting to conceal whatever window he had open in the courtroom. Whenever deputies or investigators were nearby during this time, Eppinger's attorney, Eric Johnson, was seated next to Eppinger. On May 19, 2023, at 185 Central Avenue at 10 a.m. in the large jury room on the 7th floor of the courtroom, jury selection began. All the attorneys and defendants were present in the courtroom, and Mr. Eppinger was wearing a great pinstripe suit jacket. Eppinger was once again on the provided laptop computer. At around 10:30 to 10:45, Captain Moncrief took special notice of Mr. Eppinger's activity on the laptop, and was able to take a picture of Mr. Eppinger on the screen of the computer. Although the photo is a little blurry due to the distance that the photo was taken from, you can see that Mr. Eppinger is on the same type of internet browser and in the message section of the social media application Instagram. Captain Moncrief witnessed Mr. Eppinger on Instagram message, and one of the names of the account was Karen Gates. I am familiar with the application as I had numerous social media application accounts for the past several years. Captain Moncrief was also able to take a video of Mr. Eppinger on video taken approximately 10 to 20 minutes after the photo was taken. You can see Mr. Eppinger sitting in the large jury room, typing on his laptop on the small minimized window of the Instagram application. During this time, Eppinger's attorney, Eric Johnson, was sitting next to Mr. Eppinger. On May 31st, 2023, Investigator Moore witnessed Mr. Eppinger go to Instagram on the laptop provided by Mr. Johnson. He advised Captain Moncrief of this incident. Each day of the trial, Mr. Johnson sits directly to the right of Mr. Eppinger. Throughout court proceeding, Mr. Eppinger interacted regularly with Mr. Johnson, and both were within few inches of each other, where either party may easily see what the other is working on because the computer screen is clearly visible. Based on the observation by various members of the FAST team, I was able to determine that Mr. Eppinger was utilizing the Instagram user account name @_BIGHIRIS1 @BIGBHRS1 is the Instagram account for Mr. Eppinger. I know this because there is a picture of Mr. Eppinger on the page, and he posts stories on it. Many officers know his Instagram account, and Mr. Eppinger and BIGBHRS is Mr. Eppinger's street name associated with his status in YSL. We were aware of the account at the same number I gave, and has been following this account and the name of this account is Corinne Gates. We noticed that followed approximately 3 accounts. Another account which is the Deputy Bess, who is employed in Fulton County at the courthouse. This is very suspicious to us and made us believe that the owner of the Shortness Life is another court deputy, and other member of the FASTA team, began to suspect Mr. Eppinger was communicating with Fulton deputy Akiba Stanley, who at the time was assigned as a court deputy in the same courtroom as Mr. Eppinger's trial. Over the course of the FAST time in the courtroom, there were many different times where Deputy Stanley and Mr. Eppinger had an inappropriate relationship. These will be the following points. Y'all want me to continue, guys? Y'all want me to continue? Hit the like button. Hit the like button. Well, y'all. Wait a minute, y'all. It gets juicy. It gets juicy, guys. Oh my God. It gets really interesting. People would jeopardize their job for this kind of activity. I wonder why some people do this kind of stuff. Y'all ready? Y'all ready? Y'all ready for the more juicy stuff? This is crazy. This is crazy. Oh my Lord. Y'all guys, hit the like button. You like me to continue this? All right, y'all ready? Here we go. On or around Deputy Stanley's birthday, April 4th, Christian Eppinger bought a birthday card from Fulton County Jail Commissary and gave it to Deputy Stanley in a purple envelope. It was signed Big B, which is short for Big B Wrist, which is the street name for Mr. Eppinger. In early May, Investigator Jones of the FAST team witnessed Mr. Eppinger typing on his laptop on Instagram, smiled, and looked up at Deputy Stanley. He then saw Deputy Stanley look down at her Apple Watch, typed on it, and looked up and smiled at Mr. Eppinger. This occurred several times. This appeared to be very unusual, and Investigator Jones immediately believed that they were messaging through Instagram. He let his supervisor know of this incident. On May 16, during a violent altercation between detention officer Catter and Mr. Eppinger, Deputy Stanley stood by and did not assist detaining Mr. Eppinger. He was actively resisting, and other deputies jumped in to assist. This is one of our duties as law enforcement officers, and what we are trained to do at the police academy, where Deputy Stanley attended. After the incident on May 16th, Mr. Eppinger was very upset. Deputy Stanley began rubbing his back in a comforting way and saying something like, in the effect of, "Look at me, baby." Woo! What? She said, "Look at me, baby." The name Karan contained in the Instagram account user in the middle name is the middle name of Deputy Akiba Karan Stanley. Karan Stanley. It is spelled the same way. Deputy Stanley is also associated with the street address Gates Avenue, Brooklyn, New York. This would explain why one of Corinne and Gates. Sergeant Roach spoke to Deputy Best about the Instagram page of Shortness for Life because it followed his at D Best Way. Deputy Best stated that it was his account and he thought the at Shortness for Life belonged to Deputy Stanley. He thought this because before the name of the account was Karen Gates, the account was Akiba Gates, which is Deputy Stanley's first name. Conclusion. There was probable cause to believe that Mr. Eppinger is utilizing the laptop belonging to Mr. Johnson to access and send messages to Instagram, thereby violating OCGA 42-5-18. Mr. Eppinger has repeatedly warned about this conduct and continues to engage in illegal behavior. Mr. Johnson was repeatedly placed on notice of Mr. Eppinger's illegal laptop usage. Over the course of the entire trial, from January 23 to June 23, deputies have repeatedly spoken directly to Mr. Johnson about his client's illegal laptop usage, and at least one occasion, Mr. Johnson demanded that the deputies no longer interfere with his client's violation of the law. This clearly showed that Mr. Johnson is knowingly aware of the activity that Mr. Eppinger engages in and is providing his laptop to Mr. Eppinger with knowledge that Mr. Eppinger is utilizing the laptop in an unlawful manner. OCGA 42-5-18D2 makes it a felony for any person to obtain for or procure for or give an inmate any telecommunication device. There is probable cause to believe that Mr. Johnson has violated OCGA 42-5-18 by providing an inmate, Mr. Eppinger, with communication device. Furthermore, by providing a laptop to Mr. Eppinger, knowing that Mr. Eppinger is utilizing it for unlawful purposes, there is probable cause to believe that Mr. Johnson is a party of Mr. Eppinger's violation of OCGA 42-5-18. I swear or affirm that the information contained within this affidavit and other testimony given by me under oath is true and to the best of my knowledge and belief. Affiliate A. McCormick. What do y'all think about that, y'all? What do y'all think about that? What do y'all think about that? But let me go ahead and take a look at the other search warrant, the one that was originally sent. Let me see how that one was worded to see if Mr. What's the name was really mentioning it. Hold on, y'all. Just a second. I'm gonna go up there. All right, we're gonna look at the other one. All right, let me see what the other one says. This one was done by. All right, I'm gonna read this other one. You guys ready? Mr. Johnson was in a car accident, Dr. TTH. He was in a car accident. He's really bruised up badly. His eyes is messed up. I looked at him close up. His what's eye is that? His left eye. Is that his left eye? Yeah, his left eye is really, really bruised and messed up. His face looked like he must have went like towards a windshield or something. His lip is cut. Under his chin is cut. His whole left hand and stuff is really messed up. So no, he hasn't lost any weight. He looked the same as I've been seeing him. He hasn't lost any weight. He's just banged up. All right, let me read the other one. All right. Affidavit having been made before me by T. Davis of Georgia, certified peace officer charged with the duty of enforcing the criminal law and has reason to believe that the Fulton County, Georgia, on the following described person, remiss or property stated detail described of person, personal property, or location. 185 Central Avenue, 303, Atlanta, Georgia. There is now located certain instrument, article, persons, or things, namely specific evidence, contraband, or persons to be searched for. During the past few months, I, Sergeant Davis, and the rest of the Fulton County Sheriff's Office, FAST team have been tasked to assist in a high-profile Young Slime Life trial, YSL. YSL. We are tasked with entering 901 Rice Street to wake up and search the defendant. Wait a minute. They are tasked to searching the defendant and loading them. I'm still going to talk about that same thing. How in the world did that individual end up having the drugs on him if they searched them before leaving the 901 Rice Street? That's another thing. Okay. To wake up and search defendant, loading the accused up into multiple vehicles to transport to 185 Central Avenue for court, providing courtroom security while the trial is unfolding, and taking the inmates back to 901 Rice Street. During the course of the trial, it has been understood that the defendants are allowed to access an electronic device, laptop, tablets, with the sole purpose to review document videos related to their case. On May 18, 2023, at 185 Central Avenue, Fulton County Courthouse, in courtroom 1C, FAST members who were sitting in the courtroom began to notice that one of the defendants, Christian Eppinger, seemed to have a second window open on the laptop. This secondary window was cropped in a small and only take up a bottom 1/4 of the physical laptop screen. This is strange since the laptop screen is at least 13 inches in size. Mr. Eppinger was obviously typing something that was on the bottom quarter of the screen. Investigator began to take notice that, but couldn't see exactly what was doing, as it appeared that he was attempting to conceal whatever window he had open in the courtroom. He made sure to minimize the screen and flip to the full screen of the alternate window whenever deputies or investigators were nearby. On May 19, 2023, at 185 Central Avenue at around 10 a.m. in the large jury room on the 7th floor of the courthouse, we began jury selection. All the attorneys and the defendants were present in the courtroom, and Mr. Eppinger was wearing a great pinstripe suit jacket. Christian Eppinger was once again on the provided laptop computer. At around 10:30 to 10:45, Sergeant Moncrief took special notice Mr. Eppinger Mr. Eppinger's activity on a laptop, and was able to take a picture of Mr. Eppinger and the screen of the computer. Although the photo was a little blurry due to the distance of the photo was taken from, you can make out Mr. Eppinger is on one type of internet browser and in the message section of the social media application Instagram. I am familiar with the application as I have numerous social media application accounts for the past several years. Captain Moncrief was able to take a video of Eppinger sitting in a large room typing on his laptop on the small screen minimized window of the Instagram application. I am requesting this search warrant in order to go through the laptop internet browser, data cookie, and social media account found within the search of the internet history and have Instagram messages, text messages, and video messages capability. I fear for the safety of the courtroom. Mr. Eppinger is speaking to another co-defendant or any other YSL member that are not in custody. Mr. Eppinger could be speaking to the route we take during the transport from jail and to court, and from the court inside the Fulton jail. Mr. Eppinger could be coordinating the purchase, transfer, and possession of illegal narcotics. The laptop specifically black colored. Furthermore, okay. So this was the original search warrant request. Okay, that was original. Did you hear what the difference it was? It didn't talk about Mr. It didn't say much about the attorney at all. It didn't say much about the attorney. The second one will specify more with the attorney on it. Did you see the difference? I'm not talking about the deputies taking so long to say something about the look at them boys, dresser locked up with them, hairdressers locked up. Ben, you funny. My opinion, I feel that all was going on there should, why would they let them? Well, they were giving him warnings, and they were giving Eppinger warnings several times. That's a lot of people talking about the same thing to somebody. It's kind of like, okay, when are you going to listen? You're going to bump your head. Listen. I'm being like a parent right now. You tell them how many times? So far, I have, there was several people who told them that he was on the computer, they were giving him chances after chances. Yeah, y'all gotta admit there was chances after chances after chances they were giving them. Yes, because they try to get themselves together, in my opinion, so that they can try to make a case against them. Well, I guess they're doing something now about it. I don't know. They're doing something now about it, but come on, y'all. Come on, let's be realistic now. They should, yeah, you're right. They should have did something about it. But how many times you got to tell somebody stop, 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 stop? Is he a lifer? What's a lifer? What's a lifer? No, bougie, thank you. I mean, how many times you got to tell somebody, hey, stop touching, stop. And then you tell the attorney that, hey, tell him. And he tell the guy, cut it out, stop it. And the guy doesn't do it. So it's like, okay, are y'all scared of this dude? Y'all scared to just like stop letting him use it? But then if you stop letting him use it, because then it become, oh yeah, he is a lifer. Yes, he is, Dr. TTH. Yep, he definitely is. I think he got like 60 something years or something like that. I mean, how many times do we have to, stop? I mean, even his attorney was telling him, hey, get off of that. Don't do that. Right. But if you turn around and stop and don't give him access to it, then you're going to go deal with the rights, his rights being violated because he now have access to look at his discovery. So you're damned if you do, you're damned if you don't. You're right. Dr. TTH said, why should he comply? Because he's a lifer anyway. He don't mind. Yeah, he's the one who shot the police officer, y'all. That's the one who shot the police officer. Bougie's right. That's the one that shot the police officer. But my thing is, so I wonder if it was a way for him to have like a laptop with no internet access, like a tablet only with the stuff in it with no internet. I wonder what that. But you remember, the jail has that public access. You could go hit the Wi-Fi on there. You can still hit the Wi-Fi on there and they'll be able to get on the internet still. But there's got to be a way to restrict it, because you could restrict your kids from going into certain things on the website, right? Okay, let me finish playing this video and then we'll end. But I just wanted to read that with you. I played his interview and all that, so he don't care. He has nothing. Yeah, you're right. He has nothing to lose, so he doesn't care. That's why they could tell him 1,000 times, and then he can come and attack the deputies while they in there and stuff. So I don't know. Well, he's off this case. Miss Sylvia, keep up the good. Oh, thank you, Nick. Thank you, Nick, darling. But okay, let me go ahead and finish playing it off. And that's why I want to read you guys the two search warrant, and you see how the difference it is now. And I remember I told you the first search warrant was basically illegal for them to get the computer of the attorney, right? Why didn't the lawyer have his computer in guest mode with Wi-Fi turned off? You know what, H? I think that would have been a good idea, but I don't know. To me, I don't know if they were scared of that dude. I don't know if he was, because I don't know. Mr. Worldwide says, she's trouble. I don't know, because he was told several times about the usage, and he didn't listen. And it's like he was going to take everybody down with him. He didn't care who it was. He going to take them on, because he don't, like TTA said, he doesn't care. He doesn't care. And some people, you cannot be that nice. You got to be firm and strict with them. But then I don't know. He has no control anyway. Because remember, this is the same dude that, who just said it? I think Bougie. The one that Bougie said that was shooting at the police officer. I've been good, Mr. Worldwide. I've been good. So, all right, let's go ahead and finish this. And I did not know. See, here's the thing. The thing is, here's my thing. We go by at beginning, I was like, oh my God, I can't believe this guy they just got him like that. But then when you start reading it, you see how many times that they were talking to him and they gave him chances on top of chances and top of chances and top of chances. It's like, okay, from January all the way now, they kept telling you, stop getting on Instagram. They even have proof. They videotape it. They took picture of him using it. Told his attorney. And still, he was still doing. He didn't care. He didn't care. Like Dr. TTH said, he's a lifer. He don't care. So he's going to take everybody down with him. H said money talks. He probably paying a body to he could include Thug and Shannon. That is why they have interest in the laptop. I hope he didn't threaten anybody. Well, they haven't said. Well, they're gonna go check to see if anybody he threatened. But yeah, I don't know. This young man, I don't think he cares about life at all. And I pray that someone reaches him because he's so young. He's so young, y'all. So young. Look at YoungThug pants, y'all. Look at the pants. I like those pants. They got frillies on the side. So now all the other defendants cannot go anywhere, but they have to monitor their usage. Yeah, Nick, he said Thug got I'm about to come home outfit on. That's some cowboy outfit there. He got the little frillies on the side of his pants.
Watch somebody start talking about it since we discussed it on this page. Watch. Yeah, you see his lip? His lip is all messed up. It's all messed up. They're called stack jeans? Okay. Thanks, Nick, for telling me. Hey, Galatian. Yes. Attorney Brian is definitely very classy and a very, very nice man. Every single one of them is pretty nice. All of them. They're all nice individuals.
It's very sensitive. Like he didn't want to police. I mean, it's a delayed reaction.
But you know what, guys? I'm kind of glad I'm not in the courtroom anymore. I mean, I'm so glad because with all this shenanigan, you never know. People probably try to pin something on me. Let me stay in my little room. Let me stay in my little room. That's right, Doc. And we bind it in the name of Jesus. Yes, right, Galatians. Who's that lady, Sharon? That's another attorney. Those are attorneys. This lady with the blonde hair, she does it with Mr. What's his name? Oh my gosh, the one with the ponytail. Oh, what's his name? What's the one with the ponytail name? I forgot his name. Max. No. Harvey. Mr. Harvey.
When Mr. Harvey is not around, she's there with him. The one orange skirt, that's Mr. Harvey's co-partner. Whenever Mr. Harvey's not around, you know, the older gentleman with the ponytail. Yeah, Bruce Harvey. Thank you, Nick.
All right, councils, I've had an opportunity to screen my calendar. How's the 21st of June look for you? 9 o'clock. Okay, all right. Mr. Johnson, that give you sufficient time to see council, and we can go ahead and at that point in time. Yes, sir.
Yes, Your Honor.
Okay, all right. Okay, all right, well,
So, Your Honor,
yes.
so we would like the order to continue this particular matter for remand search.
Don't have to do that because you're named as a suspect. So the statute specifically exempts that particular issue out. In fact, it's in the, and you've asked me, but I'm not inclined to do that at this point in time. And I need to hear more to make some other determinations, but I'm not inclined to do that at this point. Anything else, Mr. Johnson?
If you can come up.
Your Honor,
Or use your mic table, your mics. We spend a lot of money on your mics. So you can be heard.
Your Honor, there may be issues with regards to the sufficiency of the warrant and like that.
Well, I can take that up at the time we hear the case.
Your Honor, and good morning, and good to see you. Your Honor, can we have a ex parte sealed record communication with this honorable court? Because there's other people involved as well, and I assume you know what I'm talking about, but we'd like to flesh it out with this honorable court without the state.
All right.
Thank you.
I tell you what, I'm going to go back in chambers behind 1B, and you can join me there, and Ms. Weaver, you can also come in there as well. All right.
Thank you, Your Honor.
Okay. All right. Just give me a second, Mr. Delphone. I'll make sure that I can get we'll confirm that date, and if there's anything else we need to take up, I'll apprise you at that point in time. Okay.
Yes, Your Honor.
All right. Okay. So just give me a minute.
Judge, I understand that will be lawyers only.
Yes.
So let's make sure the record reflects that the defendant will remain.
Yes. Yes, that is correct. All right. Okay. All right. You can. We'll recess, and you can join me in chambers in 1B, 1 Bravo, defense attorneys. Okay.
Y'all, he's so banged up. You see his forehead? He got a knot upside his forehead and everything. He was banged up in a car accident on Saturday.
Or the day before, whatever.
Well, let me tell you, banana phone. That is customary for them to make an offer, but they're going to trial. That plea offer is not being taken. They're going to trial in January 2024. So that is customary for them to make offers like that. But he pleaded not guilty, so that doesn't mean they're not gonna take that. No, they're not gonna take it. Trial is set for in January. Okay, let's go to the next one. Yeah, I have the documents for the I have that document. Hold on, let me open it up on my thing here so I can show it to you. That I do have that as well. Hold on a second. I can pull that up for you. Okay, I got that right here. Hold on a second so I can show it to you. And here it is right there. This is the plea. And it's done. Most defendants get this kind of stuff. This is a record. See, it says a sentence recommendation of the district attorney for a plea deal. This is a recommendation. This is not, they're not taking it. They're going to court. This is it. It is the decision of district attorney for and on behalf of the state of Georgia to charge the defendant in the above referenced case in the following offenses. And they give that. And this is, it says here, pursuant to a plea of guilty. This is a pursuant. Like if you say that you guilty, you take this saying that I'm guilty. This is what we're going to give you. Guilty of these charges, the state recommends the following. See, it says recommends the following. That they'll give them for 20 years to serve 17. So it's going to be 17 years that they're going to have as a balance probated, right? And then all of this is going to be concurrent. So concurrent mean that they're going to be put it all together as one. And then it says it's going to reduce to voluntary manslaughter, which is 20 years to serve 17, balance of concurrent. Because all of this is going to come up to a total of 17 years because they're doing everything concurrent. And then it says here that they're going to suspend the firearm possession part. And then it says here, and then it says 20 years and balances probation, no contact with co-defendants, stay away from incident location, no social media. Oh, no social media for the rest of for 17 years. That's a failure right there. No weapons, no drugs, no alcohol for the 17 years. I don't know. That's a failure one right there as well. You guys see that? Okay. Peep game, even when the trial starts, Thug is gonna get time served. Remember, I told y'all. Nick, why isn't Thug sentence pushed for a bond hearing? Because the judge has a lot of stuff. He did put in for a bond hearing now. He did put in, but that's the judge. It's at the discretion of the judge. It's at the judge's discretion, guys. It's at the discretion of the judge. It's his courtroom and he runs it the way he wants to run it. So let me go ahead and finish this last bit of footage, and then I will hold on, let me put it up for you guys. When he starts doing the motion for the hardship again, I'm gonna stop it, okay? Guys, make sure you guys hit the share button, share this video, help a sister out to get this word spread, please, pretty please. I would truly appreciate y'all for doing that. A lot of it's muted. It's not me that muted. It was the cameraman that muted this, okay? Wasn't me. So don't think I muted this. All right, I'm gonna fast forward it a little bit. See if I can get some parts where he's talking.
On the record. Mr. Is it Delfont? Font? All right, and Ms. Talley, is the 21st of June at 9 o'clock sufficient for you all?
It's good for me. Ms. Callie will be on vacation. I can up here on that.
Okay, all right, madam. We'll let you go on vacation. And council's, Mr. Johnson, that gives you enough time to seek the advice of council and take care of other business? Okay. All right, the court, as mentioned earlier, had ex parte conversations with with defense counsel. That part of the record will be sealed. What I will do is at this point, Mr. Johnson, since the computer has been returned to you, and I believe it's still in an evidence container, is that correct, or an evidence bag?
That's correct.
All right, I'll direct at this point in time that you not open that bag and that you return that to my chambers by tomorrow morning at 9:30, okay? All right. I am given what has been proffered to me at this point in time. I am going to go ahead and follow part of the dictates of 17.532C, in which the court will go ahead and appoint a special master. I'm going to identify a special master. There will be a member of the bar, is maintained by the State Bar of Georgia, and that particular person, I will have them present on the 21st of June to go ahead and to take physical custody of the computer, as well as to discuss other issues that may be raised as appropriate. This time I'll take up anything that I'll give any affected party to Mr. Johnson and any other affected party the opportunity to claim or assert privilege, and then the court will follow that particular proceeding. But I will go ahead and at that point in time, Mr. Johnson, and take up on the 17th at least, the 21st, we'll at least get you, identify your counsel, and I'll go ahead and start that particular part of the proceedings to make sure that any privileged material is in fact maintained. So, okay. So any questions in regards to what's going to happen on the 21st?
I don't have to say.
Yes, sir.
I don't know about the date, because the Fulton County Sheriff's Office took out this search warrant today, which is June 8th. If the court allows that to be executed on the 21st, that will fall outside the statutory timeline of 10 days in which a search warrant must be executed.
It hasn't been executed as of yet?
We don't have a computer, so we can't execute the search warrant because the computer is in Mr. Johnson's possession. And the search warrant is for the laptop, for the computer itself. So we have not. The original warrant that was taken out on May 30th was executed on May 31st, and a search was conducted of portions of the laptop. I'm not intending on utilizing that evidence or contesting that search warrant was bad. The new one was taken this morning. And per the court's order, Mr. Johnson has possession of that laptop. It was returned to him on Tuesday morning this week. And so we will run into a technical issue.
Okay. Can he tender, or can we remedy that by him going ahead and providing that laptop today?
Yes, Judge. If he provides it to the Fulton County Sheriff's Office, even if there's a directive from you not to search it until the 21st from the special master, I think if he turns that over, if it's executed, then we're fine when it comes to the statutory deadline.
Okay. Mr. Johnson, can you turn that over to the sheriff's office? Who's your point of contact?
It's investigator Coleman, who's right here, Judge. He'd be acting on the search warrant.
Can you turn that over or tender that by 2 o'clock today?
Your Honor, as I drive, I mean, I'm going to be able to get to you by 2 o'clock today. I'll have to go retrieve it. I don't have it in possession right now.
Sir.
You're saying that have it to you by 9:30 in the morning tomorrow morning. I definitely.
We just don't want to run into any problem with it being outside the parameters of execution of the warrant.
Tomorrow morning works for the state judge. That's
As long as it's tendered to my chambers.
as long as it's turned over to the Fulton County Sheriff's Office and
Okay.
then to effectuate the search warrant, the execution of the search warrant. Now, the search warrant is for the laptop itself. We'll take an additional search warrant for a forensic download of that at the appropriate time, but we have to take physical possession of the laptop. and
Okay.
execute the search warrant.
All right. Mr. Steele?
Your Honor, I would like the court to do two things, if you don't mind reviewing, based upon Mr. Delphon's representation and based upon what I just heard from Mr. Johnson. The search warrant is invalid because it states that this property is at 185 Central Avenue, and it's clearly not there when it was signed. So the state, unless they have a good faith belief, does not even know that this computer is in Fulton County. So the search warrant's not a valid reason to take it. Second of all, giving over a lawyer's computer to the sheriff's office, even with the order, I would again ask that the court take it, and that should satisfy Mr. Delphon. What he stated is they are not going to search the computer based upon that warrant, so there is no 10-day necessity, and the court will take the computer, and then if they get another search warrant, obviously there'll be other.
Is that sufficient, sir?
I disagree with Mr. Steele, which is not surprising. But in terms of, I think the execution of the search warrant, the search warrant is for the physical laptop job itself. To execute that, the sheriff's office has to take custody of it.
Can't they get it from my office tomorrow morning
Yes, sir.
at 9:30? Will that be sufficient, sir?
Yes, Judge.
All right, so Mr. Johnson, can you turn it over to my chambers in 8F tomorrow morning at, let's just say 9:15?
Yes, Your Honor.
Okay.
And if you do it, if he gives it to the sheriff's office, in the sheriff's office, then just give it right back to you. It's been executed. You discussed this. You're gonna take custody of it. So let's give it to the sheriff, who is executed. And then we have it held in the court's possession until further order.
Yeah, until I appoint the master to then conduct the search pursuant to 17-532D.
And Judge, I don't care whether it's in your chambers or the sheriff's office has it. It doesn't make any difference. You're not going to be searching it until we have further hearing. I just want to avoid showing up on the 21st and then a enumeration gets raised that we didn't execute the warrant within 10 days. So as long as we can satisfy the statute, the sheriff's office takes it and gives it back to you.
That would be fine. So, who's your investigator?
It's investigator McCormick, Judge.
Investigator McCormick, just be in my chambers tomorrow morning at 9:15, and you can take it, and that will suffice the statute, and then you can return it directly to me at that point in time, and I'll just keep it in our chambers until such time as the case is heard on the 21st. Okay. All right. That's sufficient, counsels? Okay, under the circumstances. All right. Okay, so that's our issue in that respect. Ms. Love and Mr. Smith, this applies to you all at this point in time, given the fact that that there was in fact a new warrant that was executed this morning and the allegations therein, as well as I'm going to also, for the purposes of record, as the next court exhibit in order, has been brought to the court's attention that there is an individual who has been arrested for violation of oath of public officer, who has been alleged to have had some type of relationship with Mr. Eppinger and has been using Instagram to speak with inside and outside the courtroom. Given that, and given what has been alleged in the affidavit, which is just assertions at this point in time involving Mr. Johnson, it sets up a conflict between Mr. Johnson and Mr. Eppinger. So I'm going to go ahead and sever him at this point in time. So that's the reason why I wanted you to be here, for you to hear from me. But given that there is a definite conflict between the two, at this point, I'm going to have to do that. And I know you have objected to it, but I wanted you to hear from me.
Yes, Your Honor.
Yes. Well, you're still his counsel at this point in time, so I don't believe that that would be prudent under the circumstances.
I believe it goes directly to the issue raised as far as conflict.
Well, it would be, he certainly has a Fifth Amendment privilege at this point in time, and I don't believe that would be appropriate for him to do at this point in time. So, Mr. Eppinger, I'm not going to hear from you at this point. I believe that you probably need to seek the advice of counsel in that respect.
And Your Honor, just out of curiosity, is the court willing to hear a request or a motion to reconsider later today? Is the court willing to entertain that?
Madam, I'm duty bound to of course, listen to anything you would file at this point in time. But I think the problem that or the challenge that the court's gonna have is, since the new affidavit alleges, unfortunately, that Mr. Johnson may be involved, then that sets up a conflict. And I don't believe that would be prudent for the court to go ahead and continue this particular issue with Mr. Johnson. That's the reason why. And also, just to flesh out the record in this respect, I have said under many circumstances before that this is a security issue, and the court's responsible for the safety of all parties in this particular case, and communications and other things that have been attempted to be inserted in this particular courtroom, the court definitely has an interest in making sure that everyone's safety is of paramount. So for those reasons, I'm going to go ahead and sever at this point.
And just for the record, Your Honor.
Sir.
Just for the record.
Yes, sir.
Mr. Everett has applied to any
Okay, that's fine. All right. And we'll revisit that as an appropriate time. Let's just get through the next proceedings and see what happens. Okay.
Thank you.
All right. So, if you could take Mr. Eppinger, please. He can be removed at this point in time.
Judge, the appointment for the Defendant District Attorney's Office was.
Has that been filed, sir, with the clerk?
I believe it was filed on my office, Judge, but it has now remedied that.
Just check Odyssey, or have Ms. Love check Odyssey, or your office to check Odyssey, I should say, just to make sure it's been filed. I was looking for a copy this morning to make sure. Yeah, we can go ahead and do that. I'll accept that in open court. I'll also mark the affidavit for search warrant as the next court exhibit in order. All right. You may.
The statement that the appointment order is for the Defendant District Attorney's Office to handle the matter of the search of Mr. Johnson's computer only. I believe that based on the court's ruling, that concludes my business.
That should conclude your business, sir. I will include the appointment letter as the next exhibit in order, and we will see you all on the 21st of June, or you, sir, specifically, at 9 o'clock in courtroom 1C. Okay.
Yes, sir.
All right.
Nice to see you.
Okay. Nice to see you. Okay. All right. We're gonna turn things over to Ms. Love and Mr. Smith. You can go ahead and take the seats at this point in time. Yes. Yes, sir. Say again? No, not at this time, sir. Not at this time. Okay. Just court's exhibits in order.
Mr. Johnson. Yes, sir. On the 21st, did you bring in all of your notes from just for the time being from the jurors? Yeah, for the jurors. Yeah, did you bring all that? Just the things that Mr. Randolph and Mr. Johnson gave you with this whole lot of those for the time being, okay?
And USB drives as well, Mr. Johnson.
Okay, I'll put it back. I'll transfer it from the USB drive to my computer, but I'll put it back.
No, just the individual drives they gave you, like we gave everybody else, as well as the juror information.
You want the actual drive itself?
That as well as the printed copies that we give about the juror information.
I'll bring everything I have.
Okay, thank you, sir. All right, Mr. Randolph, let's start off with 1788, sir.
Yes, Your Honor.
1788, please.
Okay, yeah, I'm gonna stop this. This is a little bit getting on my nerve now. All right, Bougie said Rico was definitely a stretch. Yes, it was. I agree, but his client was violating rules. I believe they're going to hold him accountable since he advised him several times according to the subpoena. Why isn't Doug defense pushing for the bond? Hope he doesn't get disbarred. No, I don't think he could. I mean, he can't get disbarred for something minor like that. That's very minor, y'all. Very minor. And you got to remember, the court gave them approval for them to be able on the computer. Now, I mean, he can use so many excuses of why he wasn't babysitting him. You know what I mean? It's not his job to babysit. It's the deputy's job. And if they saw him doing that, the other thing too, they could have just put in an order from the court once they told him that to restrict him from. But then that's his right too. So they should have put an order in for them to have him restricted from going in the internet. But he has a right to look at his discovery. So it's a catch-22 on that. It's a catch-22. So I don't even know what the solution would have been. Yeah, I don't even know what the solution is gonna be. Cause you try to I don't know. I don't know what's going on. I still cannot get into my account. I changed my password and all that kind of stuff, and I still have issues. It's not sending a prompt to my I'm about to get off. Yeah, I'm getting frustrated with this phone of mine because it's locked me out of my own device. And this is getting on my nerve. This Google crap, man, it's not helping me out. It's locked me out of my own account. It says verify as you. I verified as me. Then it's going to tell me, oh, you tried too many times. There's no virus in here. Stop it. I'm not doing this no more. All right, guys. I'm about to get off because I'm frustrated with this stupid phone of mine. I still can't get into my stuff. You guys have a wonderful night. Don't forget to show some love to the channel. Share. If you think this is worthy, if you think this is good information, why don't you help a sister out? Donate. Help me to not absorb all of the expenses that I have going on in this YouTube world, travel, getting these documents and stuff. You know, help a sister out. That's all. Not everything is free now. Gotta remember, not everything is free. Good night, people. Oh, I forgot to put my little Cash App stuff up. Next time I'll put it up. I know I don't ever put it up. How I expect you guys to do something and I don't even put it up. Go figure. I gotta go figure out how to get them into my phone now. I don't know. I reset it and it's still giving me trouble. It tells me that I'm supposed to get a thing to tell me that I can log in, and it's not doing it for me. Help me. I want to scream, y'all. I want to scream, but I gotta go. Blessings to you, Nick. See you later. All right. God bless you, everybody. Bye.